The roads did not change. The system behind them did. And if you are over 65, driving the same way you have for decades, February 2026 is the month that could cost you more than you expect. Not because you became a worse driver, not because you broke a law you understood, but because enforcement shifted underneath everything you trusted, and it happened without a single headline reaching most people in time. What makes this moment different from every year before? It is invisible. The roads look the same, the signs look familiar, the intersections feel routine, but behind all of it, a layer of automated systems is now active, funded, approved, and already issuing penalties to drivers who never saw it coming. Cameras that do not blink, algorithms that do not offer warnings, databases now linked directly to insurance providers and state licensing agencies. The margin for small mistakes has collapsed, and the drivers paying the highest price right now are not reckless. They are experienced. They are cautious. They are people who assumed the rules had not changed because no one told them otherwise. Most of these enforcement updates were not announced in ways that reach everyday drivers. They were buried in state transportation bulletins, municipal council approvals, and insurance industry policy adjustments. They rolled out across jurisdictions at different speeds, in different formats, and with almost no public warning periods. That is the part most people miss. The laws themselves may not feel new, but the way they are now enforced is fundamentally different from anything that existed 5 years ago. And for anyone over 65, the consequences stretch far beyond a single fine. They reach into insurance premiums, license renewal processes, medical reviews, and financial stability in ways that compound over time. Here is where many careful drivers first get caught. For years, holding your phone at a red light felt like a safe pause. The car was stopped. You were not moving. Checking a message or glancing at directions seemed harmless. That assumption is now a direct path to a citation in more than a dozen states that have shifted to what enforcement agencies call primary enforcement of distracted driving laws. Under this framework, an officer no longer needs a secondary reason to stop you. There is no requirement for a broken taillight or an illegal lane change. If an officer observes a phone in your hand, or even the glow of a screen reflecting off your face at night, that alone is now sufficient to initiate a traffic stop. The definition of distracted driving has expanded as well. Scrolling through a playlist while stopped at an intersection, tapping a screen to dismiss a notification, holding a device to check navigation, all of it qualifies under the updated enforcement guidelines already active in multiple states across the country. For drivers who have spent decades treating a red light as a brief personal moment, this represents a significant shift. The legal position is now clear. If you are seated behind the wheel and your vehicle is in a driving lane, you are considered to be operating the vehicle regardless of whether the car is moving. Your hands are expected on the wheel, your phone is expected out of reach, and if that expectation is violated, the system does not issue a reminder. It issues a citation. The financial weight of that citation is where most people are genuinely surprised. First offense fines now range between $200 and $500 in many jurisdictions. Court fees and administrative charges often push the total higher, but the ticket itself is not the real cost. Insurance companies have reclassified distracted driving as a high-risk behavior, equivalent in many models to speeding or at-fault collisions. A single citation can raise premiums by 15 to 30%. That increase typically remains on your record for 3 to 5 years. For a driver paying $1,500 a year in coverage, that translates to an additional $225 to $450 annually, compounding quietly in the background long after the original incident is forgotten. For seniors, this impact is sharper. Age-based risk models already elevate premiums for older drivers. A distracted driving mark intensifies that calculation. And unlike some minor infractions, distracted driving citations are rarely removed early from a driving record. Once it is logged, it stays. What most people do not realize is how small the adjustment needs to be to avoid this entirely. A simple vent-mounted phone holder that keeps the device out of your hands costs less than a single tank of fuel. Most modern smartphones are capable of reading messages aloud, making calls through voice commands, and delivering turn-by-turn navigation without any screen interaction. The habit shift is minor. The financial protection is significant. But distracted driving enforcement is only the surface of what changed. The next layer does not involve an officer at all. It does not require a traffic stop, a conversation, or even a moment of eye contact. It operates continuously, silently, and with a precision that leaves no room for explanation after the fact. Automated speed enforcement has entered a phase that most drivers have not yet recognized. This is no longer a matter of fixed cameras sitting at known intersections. States have rolled out artificially intelligent monitoring systems, particularly in construction zones, that track vehicle speed from the moment of entry through the entire length of the zone. These systems are paired with radar, timing algorithms, and license plate recognition. If workers are present and your speed exceeds the posted limit, even by a narrow margin, the system records the violation and a citation arrives by mail. There is no officer waving you over. There is no discretion. There is no conversation. What catches experienced drivers is how these zones activate. A single worker standing behind a barrier is enough to trigger enforcement. Temporary signs may appear identical to inactive zones you have driven through dozens of times before. And because these work zones shift locations regularly, relying on memory is no longer a reliable strategy. The citation arrives days later, and by then, contesting it is nearly impossible. The system logged the speed. The speed exceeded the limit. The record is closed. The penalty structure escalates. In some states, the first violation is issued as a warning, which creates a false sense of security. The second offense triggers a fine around $150. The third jumps to $300 or more. And even in states where these are classified as non-moving violations without license points, the data is increasingly being shared directly with insurance providers. Your license may remain untouched, but your premiums adjust based on a pattern of speed-related enforcement that you may not even be aware is accumulating. School zones are following the same trajectory. Automated cameras tied directly to school schedules are now active or expanding in states across the country, including Ohio, Pennsylvania, and Florida. These cameras activate 30 minutes before school begins and remain active until 30 minutes after the final dismissal. During those windows, speed limits often drop to 15 or 20 miles per hour. Exceeding that reduced limit by as little as 10 miles per hour triggers an automatic citation. There are no flashing lights. There is no immediate feedback. The letter arrives days later, and by then, the opportunity to contest is extremely limited. The most common reaction from sighted drivers is confusion. They did not see the sign. They entered the zone just as enforcement became active. They were decelerating but had not yet reached the posted speed. Courts have consistently ruled that drivers are responsible for knowing when school zones are active and adjusting immediately. The cameras are legally upheld. Appeals rarely succeed unless a clear technical malfunction is documented. Navigation applications are beginning to mark these zones and known camera locations based on municipal data and user reports. These alerts are not an invitation to speed. They are an early signal to check your surroundings, scan for signage, and assume enforcement is active. Time awareness matters as well. If your daily routine includes driving through residential areas during morning or afternoon hours, building a mental buffer into your schedule can eliminate the most common school zone citations. The system does not care whether children are visible on the sidewalk. It only cares whether the enforcement window is open. Now there is a shift that reaches beyond cameras and speed altogether. It redefines the margin of what it means to be legally sober behind the wheel, and it has already begun reshaping enforcement in ways that affect social habits millions of drivers have trusted for decades. For as long as most people can remember, the legal blood alcohol concentration limit in the United States was 0.08. That number was treated as a firm boundary. Stay below it, and you were considered safe. That assumption is no longer reliable. Several states are now moving toward a lower threshold, modeled after what happened in Utah years ago when the legal limit was reduced to 0.05. Fatal crashes involving impaired drivers dropped significantly in that state, and the results drew national attention. Legislators in Washington, New York, Hawaii, and other states are actively pursuing similar reductions. Some jurisdictions are already enforcing stricter interpretations under existing statutes. The difference between 0.08 and 0.05 may seem small on paper. In real life, it is the difference between driving home after a single glass of wine with dinner and facing a charge that carries the same penalties as a traditional impaired driving arrest. License suspension, mandatory ignition interlock devices, fines ranging from $500 to $2,000, required education programs, possible jail time, insurance premiums that escalate dramatically for years. For older drivers, this matters even more. Metabolism slows with age. Medications interact with alcohol in unpredictable ways. Body composition changes alter how quickly alcohol is absorbed and how long it remains in the system. A drink that once had negligible effect may now push blood alcohol concentration higher and keep it elevated longer than expected. The weight charts, timing estimates, and drink counting rules that people have relied on for years were never precise. Under the new threshold, they become dangerously unreliable. The simplest rule in this new environment is also the most protective. If you plan to consume any alcohol, do not drive. Arrange transportation before the first drink. The cost of a rideshare, a taxi, or a phone call to a family member is always less than the cost of an impaired driving charge, both financially and personally. There is another shift that is reaching drivers through their wallets in a way that many did not anticipate. For years, electric vehicle owners benefited from lower operating costs, federal incentives, and exemption from traditional fuel-based expenses. That exemption is ending. Roads in the United States have historically been funded through gasoline taxes. Electric vehicles do not consume gasoline, which means their drivers were not contributing to the infrastructure they use daily. As adoption increased, states began facing measurable funding gaps. The response has been new annual fees for electric vehicles, now active in more than 40 states. These fees typically range between $100 and $200 per year, with some states implementing sliding scales tied to vehicle price or automatic annual increases. For electric vehicle owners on fixed incomes, this can feel like a surprise expense that disrupts careful budgeting. Whether the fee is fair relative to what gasoline-powered drivers pay in fuel taxes is a separate debate. What matters is knowing the fee exists before it appears on a registration renewal notice. Several states are also piloting mileage-based road usage charges as a testing ground for broader distance-based taxation. Some versions rely on self-reported mileage. Others use onboard telematics. The direction is clear, and once standardized, driving costs will be tied directly to distance in ways most people are not accustomed to tracking. Beyond financial enforcement, there is a physical dimension to the changes taking effect. In several states, the definition of reckless driving has expanded, and law enforcement has been given broader authority to seize vehicles on the spot if certain behaviors are observed. Actions that were once classified as exhibition of speed or careless driving are now treated as serious offenses. Aggressive acceleration, tire spinning, and participation in informal street gatherings can trigger immediate vehicle impoundment for up to 30 days. There is no grace period. There is no drive-home option. The vehicle is towed, stored, and held. For seniors, the assumption that these laws only target young drivers is not entirely accurate. A sharp acceleration to merge into fast-moving traffic, a momentary loss of traction on a wet surface, or simply being present near a group of vehicles engaged in risky behavior can trigger penalties. Storage fees alone can accumulate to $1,500 to $3,000 over a 30-day impound period before the citation itself is addressed. Insurance consequences follow. The message from state enforcement agencies is unambiguous. Tolerance for what was once considered minor aggressive driving has disappeared. Now, there is one area where the news appears cautiously positive for older drivers, but it carries conditions that are easy to overlook. Several states have raised the age at which mandatory behind-the-wheel road tests begin for senior drivers. In some cases, retesting is not required until the late 70s or even 80s. This reflects data showing that older drivers as a group tend to be more cautious, less aggressive, and less likely to commit moving violations. On the surface, this is a meaningful recognition of driving experience, but at the same time, states are tightening other parts of the renewal process, particularly vision testing and in-person verification requirements. In states like California and Florida, drivers over a certain age can no longer renew entirely online or by mail. They must appear in person at the Department of Motor Vehicles. The stated purpose is safety, including vision assessment, physical mobility evaluation, and identity verification as part of fraud prevention. Scheduling delays are common, appointment availability is limited, and if a required in-person visit is missed and the license expires, reinstatement is not a simple restart. It may require written examinations, road tests, and full documentation from the beginning. For seniors who depend on driving for medical appointments, groceries, or family care, an expired license due to a missed appointment can be devastating. The prevention is straightforward. Read renewal notices carefully the moment they arrive. If the notice specifies in-person appearance, treat it as urgent and schedule immediately. Connected to this is a change that affects every driver regardless of age or record. States are moving toward what officials describe as a high-security identity framework for driver's licenses. Renewal now requires what agencies consider gold standard documentation: birth certificates, verified social security numbers; for non citizens, proof that directly links license validity to visa status. If a visa expires in 6 months, the license may now expire in 6 months as well. No extensions, no grace periods. At the same time, digital driver's licenses are rolling out across multiple states. These exist in secure smartphone wallets and can be scanned by law enforcement or airport security. They are encrypted and tamper resistant. But digital credentials do not eliminate the requirement for periodic in person verification. Some states are making in person visits more frequent specifically because digital systems exist. The goal is confirming that the person behind the credential is real, not generated, and not fraudulent. Even if you have a digital license on your phone, you may still be required to appear in person every few years. Assuming otherwise can result in a license that quietly becomes invalid overnight. Driving with an expired or invalid license carries consequences that extend far beyond the traffic stop. Insurance coverage may be denied. Citations become more severe. And reinstatement can require starting the entire licensing process over from the beginning. There is one more enforcement expansion that is already catching thousands of drivers unprepared. Move-over laws have existed for years, and most people associate them with police vehicles and ambulances. If flashing lights appeared on the shoulder, you moved over or slowed down. In 2026, that requirement has been significantly broadened. The law now applies to any stationary vehicle displaying hazard lights: tow trucks, maintenance vehicles, ordinary passenger cars stopped on the shoulder with their hazards blinking. If you are traveling at highway speed in the lane closest to the shoulder and you pass a stopped vehicle with hazard lights without changing lanes or significantly reducing speed, you may now be committing a moving violation. Fines have doubled or quadrupled in multiple states. Penalties can range from several hundred to over $1,000, often with points added to your driving record. The expansion is driven by the alarming rate of roadside fatalities involving emergency responders, tow truck operators, and stranded motorists struck by passing traffic. For seniors, this requires a deliberate shift in scanning behavior. Flashing lights ahead are no longer something to register at the last moment. They are an early warning. The moment hazards or emergency lights become visible, checking mirrors and planning a lane change should begin immediately. If moving over is not safe, reducing speed significantly until you have cleared the stopped vehicle is the minimum legal requirement. This is not only about avoiding a fine, it is about protecting someone in a vulnerable situation. That stopped vehicle could belong to your family member, your neighbor, or you. And there is one final shift that affects families directly. States are restructuring how new drivers earn full driving privileges, placing far greater weight on clean records during the first year. Many states are standardizing graduated licensing systems that replace second road tests with 12-month clean record probation periods. Under these frameworks, a single ticket, a single at-fault accident, or a single documented violation during the probation period can freeze progression or push the new driver backward in the system. Nighttime curfews are being moved earlier. Passenger restrictions are tightening. Learner permit holding periods are extending from 6 months to 9 or even 12 months, with increased emphasis on supervised nighttime driving experience. For parents and grandparents helping young drivers navigate this system, the message is clear. New drivers need more guidance for a longer period than ever before. The system is designed to test consistency, patience, and judgment over time. The inconvenience is real. But states with stronger graduated licensing frameworks have documented significant reductions in fatal crashes among young drivers. The data supports the structure, even when the structure demands more from families. Everything described here points to a single reality about driving in the United States in 2026. A license is no longer a one-time achievement. It is a performance-based credential under continuous evaluation. Automation has removed discretion. Data sharing has amplified consequences. Enforcement has shifted from reactive to proactive. The drivers who navigate this environment successfully are the ones who recognize the shift early and adjust before a violation is recorded, not after. These changes are not slowing down. New enforcement systems are being approved in additional states every month. Insurance data sharing agreements are expanding. Automated monitoring is becoming more precise, more connected, and more difficult to contest. The window between a quiet policy change and its first penalty arriving in your mailbox is shrinking. What was forgiven last year is now recorded. What was warned is now fined. And what was fined is now linked directly to your insurance, your license status, and your financial future. The system does not pause for people who were not paying attention. It simply moves forward, and the record it creates follows you. If this reached you before a citation did, you still have the advantage. Subscribe now and turn on notifications. These enforcement changes are evolving faster than any single video can cover, and the next update you miss could be the one that costs you. Staying informed is no longer optional. It is the last layer of protection the system cannot automate away.